Since work product seems to be a little bit tricky, here's an attempt to clarify a little bit what we're talking about. So before we actually talk about work product, it might be helpful to just have a reminder on the scope of discovery, which is relevant to work product. And the basic scope is that you get any non-privileged matter that's relevant to any party's claim or defense. So you can seek discovery of information relevant to your own claim or defense or the other side's. And non-privileged here means something that is either not a privileged communication, such as attorney-client or doctor-patient privilege, or it could be work product. So the two big categories of privileged matter are privileged communications, which are totally off limits, and then work product, which is really the topic for this discussion, exactly what work product is. Okay, so with that backdrop, let's talk about what is work product, since this is outside the traditional privileged communications. So there's two basic types of work product. I've separated them into documents and information. And the box for documents is intentionally larger because that is the majority of what we're dealing with in real life for work product, that it's something that is in a document. And this is embodied in Rule 26b(3) of the Federal Rules of Civil Procedure, even though the topic headline says trial preparation materials. If you actually read the provision, you'll see it's not just trial preparation, it includes things in anticipation of litigation. So work product is a document that's prepared in anticipation of litigation or trial, not something that is routinely done. So like a police report at the scene of a crime that's done in every case would not be work product. Whereas an opinion somebody wrote for a client about whether or not they would violate someone's patent in anticipation of litigation would be work product. And for work product documents, it's done by not just attorneys, but by the party itself and other representatives of a party. So it could be an attorney, that's a lot of it, but it could also be a technical consultant, or it could be an insurance, a financial consultant, anyone who is working on behalf of the party in anticipation of litigation. So that is the traditional category under 26b(3). Now there's a smaller box that is a little more complicated, that is work product, that's information that basically is not in a document. So how would you have a work product that's not in a document? Well, the classic case is the Hickman v. Taylor case. So the information in that case that wasn't in a document had to do with the interrogatories posed to the attorney, trying to get the attorney to say what people had told him. So the problem there, the Supreme Court said, was that it was impossible for the attorney to orally tell and separate out the facts people told him from his personal opinions about the case. So although we have 26b(3), which covers most things in terms of documents, to the extent there is no document and the information is from an attorney, would reside in their head, there's no document, then you're talking about the right-hand side. And I put law in there just to remind you, we're only talking about lawyers here, not representatives. So for this kind of information, Supreme Court has said it's off limits. You can't get it because we don't really want attorneys just testifying. That creates problems in terms of attorneys maybe not saying things and not properly representing their clients. So can you get the work product? Well, a lot of it depends if you're talking about a document versus the attorney information, but that's not the only thing. And Rule 23 actually gives a little more information. So again, there's two things that we want to think about. On the left side is the basic rule that says you can get work product if it's otherwise discoverable under 26b, which was the first slide I showed you. It's in the scope of discovery and that it's relevant to a claim or defense. So that's just saying what you normally get, like you normally can't get discovery unless it's within the scope that's relevant. And what you have to show, you don't automatically get it unlike other discovery, is that you have to show that you have a substantial need to prepare for your case, and with you can't get the equivalent by other means without undue hardship. So it's a two-part test, both that you need it and that without undue hardship you can't get the substantial equivalent. So going back to the Hickman case again, they said that the attorney there could get the substantial equivalent because although the attorney wanted testimony from the attorney, there was also lots of public testimony, there was opportunity for depositions, lots of different other means through standard discovery techniques to get the equivalent, so you can't show substantial need that you need that material. When would you possibly have that showing? Well, you might have that showing if you're trying to get something that has changed. For example, you want a photograph of a scene of an accident, and that scene has now been fixed such that you can't see the original situation anymore, and only one party might be in possession of the documents. That might be a good situation. But there's a major caveat, and that's the stuff on the right side in the red, and that is that even if you have work product that fits this two-part test, the court is supposed to protect against disclosures of mental impressions, conclusions, opinions, and theories of a party's attorney or other representative. So this is sometimes summarily called opinion work product. In other words, if a document is solely opinion work product, you can't get it at all, absolutely off limits. The most confusing issue is if you have a document that has partial opinion and partial factual work product that you can't get the substantial equivalent of, and yet you need. In that case, where it's a mixed document, what the court will order is that the opinion work product will be redacted and you just get the factual work product. So the very one more example is something we talked about in class is, well, when would you have an opinion work product? So this is an example where somebody is asked during a deposition, what did the lawyers tell you about pitfalls in the case? So here, even though the question is posed not to an attorney, for this witness to reveal it, they would have to say what the lawyers told them. And in doing so, the witness would be revealing the attorney's opinions about the case. And that would be going back here to the part in red, the attorney's legal theories, opinions, and impressions about the case, which is not permitted. So I think there's a good reason not to answer the question under this part. And the very last thing is just, to put it all in perspective, the big picture when you're trying to get discovery is it relevant to a claim or defense? Even if it is, then you have to ask the second step is it privileged? Now, if it's absolutely privileged, that means you can't get it at all. And the two big types are either a communication that's privileged, such as attorney-client, doctor-patient, priest-penitent, or that it's solely opinion work product. There's no facts at all, just opinions, which were the red highlighted thing you absolutely are barred from getting. If it's not one of those, then you consider whether it is regular factual work product, and then if you can meet the two-part test, the court will allow you discovery. So that's a basic overview of work product. Hope that helps.